Welcome to the program. I'm Mark Imperial. This segment's being brought to you by booksgrowbusiness.com. It's where busy professionals get their books done so they can educate their consumers, grow their practices, and to leave a legacy. We're doing a series of spotlights on remarkable attorneys across the country with a focus on elder law and or estate planning. And joining me on this segment is Judith Grimaldi. Judith, welcome to the program.
Thank you. I'm happy to be here.
Judith, I know that the topic is a broad one, so please tell us a little bit about your areas of focus and the types of clients that you help.
So I'm what's called an elder law attorney, and our practice areas are, of course, elder law, which is an umbrella for long-term care planning, could be Medicaid planning, asset protection, of course, estate planning, and we like to use a safety net type of planning that allows for lifetime documents like a power of attorney, healthcare proxy, as well as afterlife documents like wills, trusts, and probate avoiding kinds of planning. We also do estate administration. And as we've learned more and more about Medicaid and the world of disability, we've become kind of focused additionally on special needs and special needs children and families with special needs children. So that's our umbrella. We try to be the family law attorney for the end of life, so that we hope to be able to fill in the gaps for a person's pre-retirement and post-retirement.
So I know that this recent pandemic has shined a huge spotlight on sort of the lack of information that surrounds, elder law. Can you tell us a little bit about like some of the most common challenges people face in not being properly prepared?
When this pandemic hit, and our population, which was skewed towards retirement and post-retirement and the later years, we all faced our vulnerability straight in the face. And we realized that we needed to get our legal house in order. And as we watched our elders, the people we love, have to communicate through glass windows or barriers, we realized that having a representative to be able to speak for us became crucially important for addressing healthcare needs. So healthcare needs came to the forefront, and the tools that family and caregivers of the most vulnerable, elderly and disabled, became crucial. We had families who told us they couldn't visit their children for 3 months, who were in institutional or group settings, and caregivers who said I couldn't visit my spouse who was in a nursing home. But so we knew if they had been equipped with a power of attorney, a healthcare proxy, those tools, HIPAA releases, they might have been able to be more effective representatives during the COVID. So everybody became quite aware. And I had calls daily for, I need a power of attorney quickly. How can I get my loved one to execute a healthcare proxy? I did my fair share of window executions, front stoop executions, tops of car executions, backyard executions, as we tried to get these done very quickly. It's continued. The interest in getting these, what I call safety net documents, has continued. So I'll explain the basic. In fact, my partner Joanne Seminara and I wrote a book. It's called 5 at 55, the 5 legal documents you need by age 55. First one being power of attorney, which is where you would appoint someone to be your legal representative in all legal and financial areas. In New York, we have a very specific drafted document, but across the country, there are similar versions. If you do one in New York and it's properly executed in New York, it will work in Florida. If you do one in California, it will work in Arizona if it's done properly. But it's best to try to get your state one done for yourself. So power of attorney becomes the legal and financial ability to appoint a legal and financial clone for yourself. Whatever you could do, your agent steps in your shoes and can do it as well. But that isn't enough. You really have someone who you might want to do more personalized kinds of things like healthcare decision. And that document is called a healthcare surrogate. Some states call it a healthcare proxy. Some call it a healthcare representative. Again, it's a document where you can appoint an agent. On this one, they really want to make sure that you have one spokesperson. Doctors don't like medical decisions made by committees. So they don't want a whole family group coming over and saying, what should happen with mama? They want one voice. So the healthcare agency allows for that. Usually they're a more simple document. They often only need witnesses. Some states require notaries, but it's a pretty official document. What my best advice for someone across the country is to find out from your Department of Health in your state what's their official document. Use that one. So when you present it to a front desk clerical person, admissions person, they'll be familiar with the documents. Even if your attorney crafted a beautiful, elaborate document for you, but the front desk person is not going to be familiar with it, you're better off keep it simple, stupid, and pick the state's form and use it effectively. Other companion documents are a living will, which is an end of life document that says, if I'm at the end of my life and I have no hope of recovery, this is my exact treatment to do. And during pandemic, people were concerned, if I had one of these documents in my file, would that mean maybe I wouldn't get a ventilator when I needed one in the middle of COVID? I assured people that two strategies. One is that if a doctor is saying a ventilator is treatment for which you will benefit from, then the living will would not apply. But to be on the safe side, maybe you should keep your living will close to your vest. Don't put it in your medical file and you're really ready to say no. So healthcare proxy, living will, power of attorney are my big three. And if you could do additional documents, then I would do a HIPAA release, which is a release that allows your loved ones to get medical information. Our federal government has a very strict privacy law that says no one can see your medical records without your permission. It really grew out of the AIDS movement when there was a great need for privacy. But now it's universally used. So a HIPAA release would allow your daughter to be able to see your blood test so she could help you make that decision, or an MRI or whatever. So that's another add-on. Of course, the other two planning documents that are not so much living, but for after you pass, is a will and a trust. And if you'd like me to talk about those, we can as well.
Yeah, absolutely. I mean, the title of your book is 5 by 55. So that was one of my questions. I was wondering, when is the right time? Because people tend to think, I'm not that old. I don't need to get that stuff yet. And then they find themselves in crisis mode. Is that about the right time, or when is really the right time or to
What
start
we
planning?
I think the right time is now, because I've had families who call me in a panic because their adult child went off to college, 18, right? They're emancipated, they're able to make their own decisions, and yet they get into some kind of health crisis while they're away at college, and the parent runs up there. They've been paying all the bills. Suddenly, they're not allowed to make decisions for their over 18-year-old child. So
Hmm.
over 18 is when you should be thinking about it, but it becomes much more crucial at 50 at 55. You give yourself 10 years before you officially retire, and there's no more official retirement anymore, right, Michael? Everybody retires at all different times, but it's, you're getting close. Your body's starting to tell you that you're vulnerable, so you have a lot of physical signals that might alert you that maybe it's time. And the other is you have some beginning to have some leisure time. Your children are grown. You no longer have to tie all their shoes and do every little thing for them. They're able to kind of fend for themselves. So you have some mental space to think about it. And the other is your peak earning years. So you actually have some discretionary income to pay for estate planning. So those three things come together. And I think that's what makes 55 a crucial time. It's about 10 years before your retirement. So you're starting to put your house in order a bit. And that's what the documents. We find that if there is going to be a sad disability, sometimes it hits in the late 50s, early 60s, and if you get past that crisis period, you're going to live to 80. So that's the other reason. Some very crucial health issues, heart conditions, start to emerge in the late 50s. I guess if you haven't taken care of yourself, your body's starting to yell at you. So that's why we pick 55. That you have the mental energy, you have the financial wherewithal, and probably your body's sending you signals.
That's great insight. Now, you mentioned you could speak a little bit about the will and the trust and how those are related. Please speak to those.
Okay, so a will and a trust are just instruction manuals. They're the instruction manuals that tell the world, your financial institutions, your family, what you want to happen when you're no longer here to direct the show. A will. So they're both instruction manuals. The difference between a will and a trust is a will is an instruction manual that you sit on the shelf, and it sits there till you die, and somebody takes it down off the shelf when you die and says, okay, here's now, it tells us what to do. A trust is something you do while you're still living, and you form it, you create it, you design it, you fund it. And that's the issue. You don't just say, when I die, do this with my stuff. you actually create retitle assets into the trust. So I think of it like a big giant safe deposit box. You could put the title to your deed to your house into the trust and retitle the deed. You could change the title to your bank accounts and make the trust the owner of the bank accounts. You could put your stocks, your bonds, whatever into this trust. And some people say, well, I don't want to give up control and put everything in a trust, then I have no control. That's why there's two kinds of trust. There's a revocable trust, which you still have control because you could be both the creator of this trust and the designer of this trust and the instruction manual writer of this trust, as well as the manager of the trust. So you're both the grantor and the trustee. So that you can have, what the beauty is though, you say, if I should become disabled, if and when I die, I'm telling you who shall step into my shoes and keep running the show without a court, without a probate proceeding, without any intervention. It's seamless. And that's what makes a living trust a probate avoiding document. I favor trust. When I first started as an attorney, I said, trusts are just money makers for attorneys. I guess I shouldn't have been so crass about it, but that's what I thought. But as I've come to have more experience, I see the gift of a trust. It really does give the person not lose control, but take control. I'm going to control who steps into my shoes. So it's not a court that's deciding. It's not my family feuding over who decides. It's not who has the loudest voice or the strongest will that decides. I decide. And that's what I think is most beneficial. So they're both instruction manuals. One doesn't operate till you die. One operates now and therefore continues to operate even when you die with a seamless transition. Probate is not horrible in some states, and in some states it's downright Byzantine. It is complex, it's complicated. It also sets the table. If you have any dysfunction in your family or disruption or disagreements, it serves the opportunity for the disruptors a silver platter and says, come to court and make a mess for us. Whereas a trust, you never go to court. So that if there is a disruptor, they have to affirmatively go to court on their own. And they often blow a lot of smoke, but they don't really want to fight. But if you hand them a silver platter, they're going to take it. So whenever there's minor children who need a state settled in a very fast way, when you have dysfunctional family, when there's someone with a disability who really can't speak for themselves or has some spendthrift problems, a will probably invites problems. A trust can avoid problems. It can't take away problems, but it can make it more difficult for them to just interrupt the flow of your estate. So I favor trust. Irrevocable trusts are more done at the very later years, 75, 85, 95. I've had people do it when they really want to asset protect or creditor protect as well as have smooth sailing at death. And many people use that irrevocable trust for long-term care planning when they're thinking ahead for what if I need a nursing home? What if there's some long-term care health issues in my future, and I want to protect my assets for my family's use and for my use. So irrevocable is more permanent and it has a very specific. All of them can have tax functioning, and as Michael, as we're listening to the changes projected on estate tax planning is becoming more and more on people's minds as they worry, will Uncle Sam take too big a bite of my estate and my family will get less. So that's wills and trusts. I know we have a very short window and there's so much more I can say about wills and trusts, and maybe we'll have to have another conversation another time to go more in depth. But did you have any other questions?
Yeah, this information is terrific, Judith. What inspired you to, focus on elder law? How did you get started in this field?
Well, I have had, this is my third career, and I think I finally found the one I really like, Michael.
I can
um,
tell. I can tell.
my first career, I was in the retail fashion industry, what it taught me is to really listen. That all clients are consumers, and that you really have to understand your product and sell your product. So that's where I learned to sell, or to explain, or to help people understand why they needed this. So I went from selling pink mohair sweaters or Pierre Cardin chairs to selling the idea that aging and preparing for aging is so much more important. And then I when I had my first child, I was doing volunteer work, and I would visit the elderly in my community, and I began to see that and this was in the late early 80s. I learned that you know, sometimes aging wasn't fun. It wasn't the golden years that we had come to expect. And I began to become more of an advocate. And I knew how to persuade people about ideas, but I didn't have the information. So I went back to school and got an undergraduate degree in gerontology. And after receiving that degree, everyone said to me, "Can't do anything with that, Judy. You have to get some sort of graduate, if you want to teach." I didn't want to teach, I wanted to do. So I went to social work school. Well, this fashionista going to social work school didn't match very well, but I learned new skills. I learned listening skills, counseling skills, understanding, really how the government benefits worked, but it wasn't quite the right fit either. And then I came upon law school. I would have gone to law school sooner, but I had young children. I had to put myself through school. I entered law school at the same time my uh, oldest son entered high school. And I thought, well, I'll finally be able to pay for his college if I could become a lawyer instead of a social worker. And I could do what I really loved, was to advocate, but with tools that would not just work on a micro level, everybody individually fixing one lady's problem and the next older person's problem, but maybe look on a macro level. And I thought the lawyer skills could blend with social work. So they came a lawyer with a social work degree or a social worker with a law degree, and entered in the elder law field. I went to law school to be an elder law attorney. And I remember my first law counselor saying to me, "You want to be an old attorney?" But so the field was so new that he or she didn't even know what I was talking about, but I knew what I wanted. And upon graduating from law school, I went at night while I worked during the day, both running a home care agency for a local hospital, as well as going to law school at night. And at the end, that's how I became an elder law attorney. So it was learning to listen to people through sales, learning to provide people with services through social work, and then learning to be a real advocate through law.
For folks listening in areas that you serve, please tell us those areas that you're able to serve and how they can find you, connect with you, and learn more.
Sure. Our law practice, and it's called Grimaldi Young. My partner is a very dynamic Asian woman and is serving the Chinese and uh, Asian community. So the two of us have formed our firm. We have at the moment, so it's Grimaldi Young Law Group. We have two offices, one in Brooklyn. And we chose Brooklyn because it's the bedroom of most of where people are and people sleep and live and enjoy their lives, so that we wanted to be community based. And we also have an office in Manhattan at 45 Rockefeller Center. So we have two offices. We have 9 attorneys in our firm. We were an all-women firm until this year. We have our first male attorney. And so we really bring that soft side. We provide both care advocacy, as I said, elder law and estate and trust and administration. And we serve all 5 boroughs. As a social worker, we often will make home visits. We'll make, as I said, I did powers of attorney on car tops in backyards. So we move around to where our clients are, especially the older community. They can't come to us, we'll go to them. I've been in nursing homes. We visit nursing homes and home care agencies regularly, so we really understand community services. So we're in the 5 boroughs. We want to be the family law, the law attorney for the family at the end of life, and anyone dealing with disability. And we can figure out Medicaid like nobody's business, get home care, nursing home care. Besides myself as a social worker attorney, one of our other attorneys is also a social worker attorney. We really believe we need to bring both sides to this growing aging problem in our city. Our cities are a growing elder city, and our country is a growing older country. So we need to really learn how to serve them. And even the Biden administration has admitted that part of infrastructure has to be services on home care and caregivers. So we think we're in the right place at the right time, and we hope that we'll be able to bring good services to family and caregivers as they face these long-term care challenges.
This has been terrific. I really appreciate you taking the time and sharing with my audience today. And
I'm very
Judith, I
happy
wish you
to.
continued success for you and for all of your clients.
if you want to buy my book on Amazon, you can find it. It's a whopping 11.96. I think some very low, modest cost. And I'd be happy to take anyone's questions as a service to you. And if you want me to give my email address, I'd be happy to do that.
Sure, go ahead and give it out.
Okay, so my email address is Grimaldi. And so since I'm an Italian American, I'll have to spell my name. And it's Grimaldi at gylawny.com. And often when I say my name, Grimaldi, they say, "Are you the pizza Grimaldi?" I wish I was. No.
Thank you so much, Judith Grimaldi. And this segment's been brought to you by booksgrowbusiness.com. It's the place where busy professionals get their books done so they can educate their consumers, build their practices, and to leave a legacy. That's all for now. I'm Mark Imperial, and thanks for joining me.